Good morning and welcome to today's webinar, Supported Decision Making for Loved Ones with Disabilities, offered by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. We have many new attendees to our educational webinar series today, so welcome to everyone as well as to those who are frequent attendees. We encourage your general questions today, so when you have a question for Steve, please note it in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions at any time. You also receive the presentation slides by email from me to take notes on if you wish. The presentation is also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a few minutes to fill out this very brief survey to offer us your feedback about the presentation. And as always, we read and value every comment that you offer to us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs. So consider a consultation or a document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started. Consultations are the best and ideal way to get your specific questions answered, have Steve understand your situation, and help create solutions and a path forward for you. So briefly, before we get started, I'd like to offer Steve and the firm a proper introduction, and then we're going to go ahead and get started with the presentation. So let's see here, I'm going to share my screen. There we go. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We offer many different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. And Steve and I are coming to you live from the Columbia Gateway community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates. We do that in several ways. Through our planning processes with our clients, we offer over 100 educational webinars and workshops in the communities we serve each year through all of our attorneys that offer presentations. And also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve, your presenter. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different membership organizations throughout the nation, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many, many others. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve talk before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. So congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me. I'd be very happy to share our story with you when we have just a bit more time. But for right now, we are going to talk a little bit about supported decision making, a very intriguing topic that was recently passed into law in Maryland in October of 2022, and Steve knows a lot about. There you are, Steve. Welcome.
Thank you, Jeff.
I need to make you the presenter, actually, don't I? There we go.
All right, thank you, Jeff. So I'm just going to switch my screen and I will take over the screen. Very good.
Okay.
And you should be able to see my desktop here in just a moment.
Looks good.
All right, and I'm going to start my slideshow.
Very good.
All right, thank you, Jeff, and good morning, everyone. Getting past a few technical difficulties. Thank you for being here with us on Good Friday. And this morning time slot, when we know you're very busy and have many things to do, it's our privilege to be with you here this morning. And I just want to wish everyone a happy Easter and Passover in advance. And I want to thank my good friend and longtime colleague, Jeff. Thank you for being here this morning, Jeff, despite being under the weather recently. And I appreciate your being here to be our moderator this morning. And I know we have a lot of people on the webinar this morning, lots of different types of people, whatever your interest may be in this subject. And I know we have just people from the general public or clients of Elville and Associates or past clients, financial advisors, CPAs, family supporters, people that have loved ones with disabilities, with family members that have disabilities, whether they are young or old. So welcome this morning. It's my great privilege to educate you about this topic this morning. And I just want to say that Elville and Associates from the outset here has been very blessed for many years to be involved in the special needs community and the elder law community, supporting people and working to benefit people with disabilities. So as I lead you through this discussion this morning, I want you to look at this topic, supported decision making. And if you have not delved into this particular topic before, I'm going to give you some information this morning that is going to really be somewhat challenging. The definition of supported decision making and the basic concept of it is not difficult, but it becomes more difficult depending on a lot of variables that might get factored into a particular situation or understanding. So as you walk through this material with me this morning, I want you to think of this as maybe an initiation into the subject of supported decision making. I also want you to look at it as a mini master class, so you're actually going to learn quite a bit, but you're going to walk away from this probably with a certain level of perception or understanding and certain challenges that you might walk away from and think, gosh, what does this really mean? And for some of you, this will be very clear, and for others, it may not be. So whatever your takeaways are from today, I just want you to know it's okay. This is a very, very simple concept in one way and a very complex concept in another way. So thank you for being here. We're just going to work through it together as we look at the fairly new law of supported decision making in Maryland. What does it mean? And what is it going to mean to each family, to each individual as we work through it? All right, I'm just going to get started into the material now. And as I do, I want you to feel free to ask questions. Jeff is an expert moderator. He's done hundreds, if not thousands, of webinars. And Jeff is very skilled. He'll stop us from time to time. I will stop from time to time if you have questions. So this will be somewhat informal, but we're going to be within our time frame and get from point A to point B as we approach the holiday weekend. So clearly this is general information. It can't be construed as legal advice, just to let everyone know that. The reason for that is that we can't give legal advice by way of webinars, but we're certainly going to give as much general information and be as specific as we possibly can, short of it being actually legal advice, which we can actually render in individual meetings following a session like this. So just please know that. Okay, so today we're going to talk about what is supported decision making. What is it and what is its purpose? We're going to talk about the new Maryland legislation, and I'm going to tell you where to find this legislation and how you can get more educated about it. We're going to talk about what is the promise of supported decision making. And remember, we had a long period of time prior to the passage of supported decision making in Maryland, where supported decision making was the law in many states. Maryland was a little bit late to the game, but maybe earlier than some states. We're going to talk about a counterintuitive subject, which is what is supported decision making not? Kind of looking at it from an opposite point of view, a counter point of view, to try to understand its relationship to financial powers of attorney and advance directives, and what is its relationship to guardianship. We're going to talk about supported decision making and how it actually works and how it benefits people with disabilities. And we're going to review the Maryland legislation itself rather briefly, and then talk about next steps. So let's get right into what is supported decision making and what is its promise. Well, supported decision making, I want you to think of it as a tool. It's a tool where someone with disabilities, and this could be an older person, it doesn't necessarily have to be a young person. It could be any person with disabilities, whether those disabilities are intellectual or otherwise. And it's a way to empower them to make their own decisions to whatever extent possible. Okay, so it's a way, it's a tool, it's a process for someone with disabilities to make their own decisions to whatever extent possible. Now, this is, as you can probably see from the very beginning, starting to be a very broad topic from a very simple concept. But we're going to get into maybe what is my definition of supported decision making in a more specific way as we go through the presentation. Now, it's a simple written agreement, or as you will see, no agreement at all. That's very confusing, and that's one of the things I want you to just give yourself permission today to be confused, because when you walk away from this, you will be processing this information and not necessarily coming to conclusions. Maryland, having no supported decision making and no good alternative to guardianship for years, basically had nothing except for whatever attorneys and courts could come up with as middle of the road agreements to guardianship, sort of guardianship. And we'll talk about more of what I mean by that. And so Maryland went from zero to this huge law that we're going to discuss. And that law provides for a person with disabilities to provide for a written agreement, to provide for a supporting decision maker, or no agreement at all. So you see, it's very, very wide open, very broad. It's a formalization of authority for a supported decision maker to actually be recognized for a person. It's an alternative to guardianship. It's an addition to financial powers of attorney and advance directives. And again, don't get panicky. We are going to talk about what is this world of self-determination and that we're actually talking about here. It's actually a tool in guardianship. It's not that you can't have a supported decision maker even under guardianship, and we're going to see that. And it's part of a paradigm shift. This is a huge shift, even though it's a very simple concept. This is a huge shift in human rights. And it's a new world of self-determination. Again, as I said, for people who are young, people who are older. Now, there were key players such as Megan Rusiano, who I had the good fortune and pleasure to meet years ago, who is now working for the ARC of the United States. And she used to be someone who worked here in Maryland for an organization called Disability Rights Maryland. And I believe Megan probably still lives in Maryland, but Megan is a person who was one of the key players to bring supported decision making and the legislation for supported decision making to Maryland. So truly, she is a champion of rights for persons with disabilities. And this led to the ultimate passage of this law in the fall of 2022. So not that long ago, probably 6 months ago. And Maryland now follows the lead of several states. And I'll just give you a few states that were the leaders: Alaska, Wisconsin, Texas, Indiana, our neighbors in Delaware, our friends and neighbors in the District of Columbia, and now several other states, including Maryland. And supported decision-making fulfills a long overdue change in the approach that Maryland was taking, this paradigm shift that Maryland was taking in the old paradigm of guardianship and definitions of what incapacity and capacity were. So, as you'll learn about me in this presentation, I sometimes get ahead of myself. Megan actually came from British Columbia, where supported decision-making was the law there and was trailblazed there, I guess is the best way of putting it. And these new concepts of human rights really came down from the United Nations mandate on human rights, that people with disabilities should be treated equally under the law and have the right of self-determination. And again, we've talked about these various bullet points already, and this was a very difficult thing to let go of for many lawmakers and many lawyers. For example, even people in the elder law world here in Maryland had a difficult time for several years letting go of the old paradigm of protectionism, the old paradigm of guardianship, fear of change, fear of fraud and abuse. All of these things, very valid things to worry about, but were things that were difficult to let go of. So why was supported decision-making needed in Maryland? Well, there was no good alternative to guardianship. And we're going to get into that later for those of you who are still wondering what I'm talking about. So guardianship, meaning the loss of rights by its very nature, versus the retention of rights, powers of attorney and advance directives, and the retention of the right of self-determination. There was no good alternative to these two things. There were no formalized ways for a person with disabilities to be supported. Now, this is where much of the confusion now starts to come in, because I've spoken to audiences at the ARC or at the various places that I sometimes am privileged to speak at. And I talk to audiences about supported decision making, and people say invariably, you know, I've been supporting my loved one with disabilities for years. What is the big deal here? You know, what is this going to mean to us? And what I'm saying here is that there was no formalized way. Now, there were lots of informal ways that your loved one is being supported, but no formal way. Now, under guardianship, there was no review, and there still is no annual review of private guardianships. There's only review of public guardianships. Now, think about that. So this whole notion of guardianship is pretty serious, right? Although it's very, very needed. No one is going to sit here and say, I'm certainly not going to say that guardianship is not needed. I'm saying that there was no alternative that was really viable in the law. No clear way for alternatives to be explored. Now, what do I mean by that? I mean that when a person was being subjected, say, to a guardianship action, they have the right to object. The person with disabilities does. But even though they have the right to appear, they have the right to object, they have the right to be heard, what happens many times is that courts, in one way or the other, ignore this. Or the court-appointed attorney in a guardianship will waive their client's right of appearance, which is very, very much probably a valid thing in some cases, many cases. But there was no clear way for all alternatives to guardianship to be explored. So supported decision-making was very needed in that regard. And along those lines, inconsistency in the judicial application of the law. Various counties, various judges, maybe not intentionally, but not really being consistent. Old notions of traditional guardianships and inequities are no longer needed because of supported decision making, because it was very needed. And what I will just call a culture of paternalism. So when we talk about the old paradigm, which is a mindset, it's an approach to the law of guardianship versus no guardianship. There is a perception, or maybe that's not the right word, there is a reality that there was a culture of protection. We want to minimize the risk to individuals with disabilities and keep them from being able to take risk. And I call that a culture of paternalism. So what were the tools that were available prior to supported decision making? And as you can see, I'm laying a lot of groundwork here. I'm taking a lot of time to lay the groundwork before we get into what supported decision making actually is. Well, the available tools were really appointments of financial agents under a financial power of attorney, appointment of healthcare agents under an advanced medical directive for healthcare, representative payees. These are alternatives to a guardianship of the property for a person with disabilities. And many of you on this webinar today are persons that are representative payees for your loved ones. Joint ownership of accounts. This may not be a good idea, but joint ownership avoids guardianship. Surrogate decision making. Surrogate decision making says that a list of persons under the priorities listed in the Code of Maryland can be a surrogate decision maker for healthcare. So that's an avoidance of guardianship tool. And then, of course, the available tools also included guardianship of the property, guardianship of the person. And when I said that there was no good alternative between guardianship and no guardianship, what I was really saying was that attorneys and courts had to really rely on what I would call consent agreements. These are agreements that would be reached if there was going to actually not be a guardianship. These are private agreements that were reached in the court under the auspices of the court to come to some kind of a settlement where no guardianship would actually occur, despite the fact that there was a guardianship proceeding in place. So all of these were the available tools prior to supported decision making. Okay, so if you're hanging in there with me through all of that dense introduction, let's talk about what supported decision making is not. Okay, again, I'm trying to come from a different perspective to give you the most impactful experience here this morning as we get towards the real meat of supported decision making. So supported decision making is not a financial power of attorney. So let's just get that straight in our minds. And we're going to have a graphic coming up on that. Supported decision making is not a way for a third person to make decisions for another. It is not a way for a third party to make decisions for a disabled person. So let's just get that straight. Supported decision making is not a way of giving authority to another person to do what they think is appropriate for the person with disabilities. Okay. Supported decision making is not a mechanism by which a person with disabilities gives up their rights. See, it is not any of those things. And supported decision making is not guardianship. Now, just for those of you who are paging through the materials before me, yes, supported decision making can be a part of guardianship, and you're going to see that's a wonderful addition to the law, but supported decision is not actually guardianship. It is far from that. Okay, I'm going to stop for just a second. That was quite a barrage of information there for the last 15 or 20 minutes. Jeff, do we have any questions so far?
Thanks, Steve. No questions as of yet.
All right, thank you very much. So as you are very patiently waiting and I should say wading into the material with me, we're now going to look at the differences between supported decision making and adult guardianship. So what you can clearly see I'm doing here is I'm very much laying the groundwork for how this all started, where it came from, what the differences are, what supported decision making is not, and of course we're going to talk about what it is. And as we get there, let's talk about the differences between supported decision making and guardianship. So guardianship, as some of you on this webinar are aware of, is about the removal of rights. So a person who goes under guardianship becomes a ward of a guardianship of the property. That person, in essence, loses their legal rights in theory to their property. Now, this is not always true. A guardianship order can be modified and so forth, but in essence, that's what it's about. And it's a removal of guardianship of a person who's under the guardianship of their person. It's a removal of rights for that person about where they can live. They no longer have the right to determine that, or about their healthcare decisions or voting. Okay, they lose those rights, for example, unless the court specifically provides for that. The person under guardianship technically has no legal choices in the old paradigm. And that's the paradigm of protectionism I talked about. No recognition of the right to take risks. So this person is deemed to be a person who is vulnerable. And of course, many people who need guardianship for that very reason, they are vulnerable. There's no question about that. We're just trying to understand the differences between supported decision-making and guardianship. Here in this presentation, we're not saying that guardianship is bad or that guardianship is good. We're simply pointing out the differences, and we're talking about supported decision-making as an alternative to guardianship where appropriate, and we're going to be talking about supported decision-making as a part of guardianship as appropriate. And again, as we talked about earlier, we're being redundant here for learning purposes. There is no review of private guardianships. So if someone petitions for guardianship of their loved one, that's a private guardianship. There's no review. And even though guardianship is not supposed to be permanent, there is a general consensus of permanency. This is my opinion. It's not necessarily a legal opinion or anyone else's opinion, but guardianship tends to be permanent, especially if it's private, because it has no review. So all of these things are kind of the differences between supported decision-making and guardianship as we continue to examine those differences. Now, along those lines, in supported decision-making versus guardianship, there is no removal of rights. So a person can appoint a supporting decision-maker without losing their rights. With supported decision-making, there is a potential for restoration of rights. So there are many people right now looking at this and saying, well, my loved one with disabilities, or the person with disabilities themselves who are under their award under a guardianship, that person is now saying to themselves, that higher functioning person, that higher capacity level person is saying, listen, I could petition the court and I could have my rights restored because I can function in life. I can exercise a higher level of capacity and self-determination without guardianship. So it's a potential way for restoration of rights. The rights to the property and person remain vested in the individual. Now, I want to make sure we're clear here. The rights of that person's property and the rights to their own person, to their healthcare decisions and so forth, they remain vested. This is the supported decision-making side versus the guardianship side. It's a paradigm of individual risk, giving the person the right to take risks. Now, some of you on this webinar are parents, brothers and sisters, nieces and nephews, grandparents, other supporters, and I want to say right from this point, you have the right to disagree here. You have the right to decide, you know, in our particular situation, and in my loved one's particular situation, this is not really a good idea, that they have the right to take risks. And so I just want to say, as you're going to see in the rest of this webinar, my experience is that certain people, for example, parents, they may be very enthusiastic about supported decision-making for their particular loved one and their situation. Some parents will not be enthusiastic. Some parents will be very skeptical or indifferent. And I just want to say that's okay. You're going to walk away from today's webinar with a certain view, and I'm going to, again, challenge you to think about this after today. Some people with disabilities will be able to appreciate a new paradigm of individual risk. They are able to be free in the sense of the self-determination world of thinking. They are able to exercise capacity in a greater way, and they will understand that and they will appreciate that. While other people who are under disability or have disabilities will not be able to appreciate this. So this is going to be a wide spectrum, and we're going to get into that, what I call the continuum of self-determination. So again, this is a paradigm of individual risk versus a paradigm of protectionism, where a person has the right to fail under this individual risk model. And you, as a family member, supporter, or even a person with disabilities who may be on this webinar today, you're going to decide what this means to you. All right, back to my bullet points. This can be part of a guardianship. Supported decision-making can be part of a guardianship if necessary, if appropriate. It can be in addition to a power of attorney. So see, this is very different from the guardianship model. And we're going to get more clear on this in just a few minutes. And it can be in addition to an advance medical directive. So let's talk about financial powers of attorney and advanced medical directives versus supported decision-making. We just talked about guardianship versus supported decision-making. So let's make sure we're framing things correctly. We just left that subject, and now we're getting into this framing, financial powers of attorney versus supported decision-making. Well, under a financial power of attorney, and I'm just going to hold up my left hand here, this is a financial power of attorney or an advanced medical directive. Both of these documents appoint agents. When I have an agent who can act for me, now I'm giving power to that agent, and I'm also saying, hey, when this certain event happens, or when I say that you have power, that's when you have power. So you have power to act for me. And this big bullet point here, number 2, is really important. The agent acts for me when I can no longer act for myself. So the agent acts for when the principal, the person who gave the power, can no longer act for themselves. So if I hold up my left hand here and I say, this is the financial or healthcare power of attorney, this is basically saying this: I will make my decisions myself, and if I can't, my agent will make those decisions for me. I'm empowering them to do that at a certain time. Now, the agent has fiduciary responsibility. They have accountability under the law, and I can terminate my agent's their right to act for me. As the principal, I can terminate that power in writing. So that's something that everybody on this webinar needs to know about. If you appoint an agent under a power of attorney and you decide you do not want that person to act for you anymore as your agent, you must terminate that in writing. And here's a very big bullet point at the bottom. When we appoint agents, we are avoiding guardianship. We are avoiding guardianship of the property under a financial power of attorney. We're avoiding guardianship of our person under a healthcare directive, because these agents who can act for us when we can no longer act for ourselves, these agents are substitutes for guardianship. Now, juxtaposing this now with supported decision-making. Here we have financial powers of attorney, healthcare directives, which are healthcare powers of attorney in the sense that they appoint agents, versus supported decision-making. In supported decision-making, there is no agency relationship. There has been no transfer of power. The power of the person, the power of the principal, the disabled person in this case, remains vested in them. The principal, the disabled person, whether they are young or old, they continue to make their own decisions with the help of their supporting decision maker. Okay, let's stop right there. Many of you so far on this webinar are probably saying, subconsciously at least, Steve, give us a real definition of what supported decision making is. I'm going to take off from this bullet point number 3 here and just give you that definition. So in my opinion, supported decision-making is basically this in a nutshell. I will make my own decisions to whatever extent possible that I can do so, regardless of my level of capacity. And this is a very big concept I'm throwing at you here. Regardless of my level of capacity, whether it's very low or very high. This is a very difficult thing to accept for some people. I will make my own decisions to whatever extent possible that I can do so, providing that I have the support to do so. So I will make my own decisions to whatever extent possible, providing that I have the support to do so. Okay, that's my definition of supported decision making. So here again, this third bullet point, the principal, the person with disabilities, lower functioning person, higher functioning person, they make their own decisions to whatever extent possible with the help of their supported decision maker. Okay, bullet point number 4, no authority for the supporting decision maker to act on behalf of the person. So remember, the person didn't give away any power, and the supporter has no power to act for that person, only to support that person. Accountability. This basically depends on the jurisdiction. So as we get into the Maryland law, to whatever extent we have the time to do so today, you're going to see that there is accountability on behalf, on the part of the supporter. The supporting decision maker's role, the person who was appointed, can be terminated. Now remember, these people can be appointed in writing or verbally with no writing. So get used to it. This is difficult for some people to accept, but it's the reality. And supported decision making is a substitute for guardianship. Let's say that you or someone you know is petitioning for guardianship of their loved one. The judge decides, because the judge, meaning the court, is the ultimate guardian. And as part of this process, the person has a right to appear. Well, that person now, and we need to be aware of this as family members and loved ones, this person has the right to appear, and they have the right, in theory and in reality, they have the right to say to the court, and the court has the responsibility to say, we have to examine all alternatives to guardianship. So if this person who is standing before me in the court has the right to appear, and they want to know, is there any other alternative to guardianship, this concept of supported decision making has to be considered. All right, perhaps the most important thing I could show you today, other than the actual law itself, is something I am calling the self-determination continuum. And the self-determination continuum is not complicated, and I'm just going to let you read through this for just a second, and I'm going to shift over to a PowerPoint slide that Jeff has been gracious enough to help me design. And this is going to hopefully clarify, as you take all of this in today and you leave this workshop and you go about your life over the weekend and in the weeks to come, I want you to refer back to this chart that I'm going to show you now. We're going to come back to this definition in just a minute. And I apologize that this chart is a bit dark, but this to me is the thing for families to understand that have a loved one with disabilities. To understand about supported decision making, but also to give greater clarification of what does this really mean. We can understand that someone has the right to make their own decisions to whatever extent they can, providing they have the support to do so. We can understand that, Steve, but how does this really fit into our lives, to the way to think about this concept? So let's start from the left side of this, and I'm going to repeat myself intentionally, the things that we've already discussed, and kind of bring it into this particular slide. So the person on the left-hand side of the screen here, this person is a person that has at least the bare minimum mental capacity to be able to execute documents and appreciate the nature of decision making. This person says, I can make my own decisions. There's no question about that. But if I can't, my agent will make that decision for me. Healthcare wise, financially, they will make those decisions with the financial power of attorney. This person has the mental capacity and they execute financial powers of attorney and an advanced medical directive, and they name their agent. So this is a person with capacity, at least the capacity and functionality, I will throw in, a non-scientific word on my part, that says I can exercise my right of self-determination. If I can't make my own decisions, someone will make the decisions for me. Now, on the right-hand side of this continuum, as we go back and forth, left to right, right to left, on the right-hand side, we have the guardianship scenario. I cannot make my own decisions, and I need the protection of a guardian. My go-to word here is the person is vulnerable. This person needs protection. There's no question about it, for whatever reason there may exist for this. So I cannot make my own decisions versus the opposite side, I can make my own decisions. So I cannot make my own decisions, I'm vulnerable, I need the protection of a guardian. Now note this last sentence. I may possibly have a supporting decision maker under guardianship. Now this is a big thing, because when Maryland went from 0 to having this massive supported decision-making law, it included the possibility of a person under guardianship not really conceptually losing all of their rights. Do you see what a big deal this is? A person can have a guardianship of themselves over them. They are the ward of a guardianship, but they can have a supporting decision maker. This may make sense in many cases, and then in many cases it may not make sense. So we are going to see where this is provided for. So again, on the left-hand side, I can make my own decisions. If I can't, my agent will make those decisions. On the right-hand side, I cannot make my decisions and I need the protection of a guardian. However, under certain circumstances, I might be able to have a supporting decision maker. Now in the middle, this is where we had no real answers in Maryland, except for the consent orders and all of those kinds of judicial agreements that I was talking about. Now we have supporting decision making, supported decision making. And what did I say earlier? In my view, is the definition of supported decision making, or at least one. I will make my own decisions to whatever extent possible, provided that I have the support to do so. So from left to right, I can make my own decisions, but if I can't, my agent will do that for me. In the middle, I will have my own decisions. That's what I do. I will make my own decisions, and I just need the support to do so. So let's stop right there. A person could have, a higher functioning person could have powers of attorney and advance directives that they've signed, but they are a person, let's say, with disabilities. So they can also obviously have a supporting decision maker, and that person will help them with their decisions. So these two things, the middle option and the left option, these are not exclusive. They can have, a person could have both. On the right-hand side, I can't make my own decisions, I need protection, but I could still have a supporting decision maker so that I have some input. I have the right to make some decisions and direct my own life to whatever extent possible. So you see, even with guardianship, we come back to the middle. We may be able to have both. These are not necessarily exclusive. And as I now page back to where I was before, in narrative form, this is the explanation of that continuum of self-determination. And my hope today is that as you leave this presentation in about 30 minutes or so, my hope is that you will come back to this and that this will make sense to you, because in my experience with clients and families, this is the best way that I've been able to derive that I could explain this very complicated subject of supported decision making in terms that make sense to people. So I hope that is helpful. Now, if those two slides were the most important slides, in my opinion, of the entire presentation today, to me, this is the second most important slide. Because as supported decision-making was being developed as far as the legislation and eventually passed in Maryland, a lot of people would have problems and challenges and confusion, which I hope this presentation will help clarify some of that confusion and provide some direction and some answers. But nonetheless, there are problems and challenges. So let's take a look at these bullet points. And again, I thank you for hanging in there with me with this very dense conversation. Some persons with disabilities understand and appreciate their new expanded rights of self-determination under SDM, supported decision making. So I mentioned that earlier. Some people are going to understand and they're going to be able to use these rights. They may be able to restore their rights from a guardianship situation. They may be able to have supported decision making implemented with their guardianship, or they may have even the ability to challenge their guardianship and get rid of it. And that's what's happening now all across Maryland. Some persons with disabilities may not understand these new expanded rights, and they may not be able to understand. And to whatever extent a person can understand, I want to make this very important point. I think that we in the special needs planning and disability community, we need to see it as our responsibility to help people with disabilities who may not be able to fully understand these new rights, to do as much understanding as possible, to get as much understanding as possible under the new law. But there's no question that we probably need to accept that the reality is some people will understand their new rights, some people will not. Some parents are going to be enthusiastic, I mentioned this earlier, about supported decision making and its possibilities. Some parents are going to be indifferent. Some parents are exhausted. Some parents are going to say, I just don't think this is going to have any value. And that's perfectly valid, okay? Some people will say, who in the world would be willing to step in and be a supporter and not even really be compensated? And I think that's a very valid opinion. I will share this brief story with you. I attended the Heckerling Conference in Florida, which for those of you who don't know what that is, that's perfectly fine. It's a massive estate planning conference, and now they include elder law and some special needs in this conference as far as subject matter in Orlando. And 3,000 or 4,000 estate planning attorneys go there, elder law attorneys go there. And I thought it was a particularly intriguing thing. I listened to the presentation of a relatively young woman who is a certified elder law attorney, and she's also the mother of a person with disabilities, a young child. And her opinion was, surprisingly, and it was very surprising, she said a couple of things that I thought were very important, however. She said that she felt that supported decision making was more of a utopian idea, and it sounded really good, but it would have lots of problems and challenges, including who would be willing to be the supporters and take on these kinds of responsibilities in the future for her child. I thought that was a very valid point. So it may be utopian, but it is a huge paradigm shift that I think overall moves us in the right direction, even though the truth of some of these bullet points is undeniable, that some people may not understand, some people may not be able to use supporting decision making. I will also throw out, just for consumption this morning, that this same elder law attorney I thought brought up some good points about special needs planning, which is beyond the scope of today's discussion. But she talked about family members perhaps being more suited to be advocates for their loved ones with disabilities rather than being trustees, which I just thought I would throw out today, and that she felt that trusteeship or the trustees of a special needs trust maybe should be professionals, people who are really more well-versed in managing money and paying bills than loved ones. So that I just thought I would share that. But the main thing about that person and their input for this discussion was really the idea that even as a young mother, on a certified elder law attorney, she felt that many of these concepts are utopian in nature and not necessarily practical. This gets back to public education on the subject, and that's why I included this bullet point here. How will supporters be educated? How will banks and financial institutions and healthcare institutions, how will the public be educated? This is something that I think all of us can take seriously. And here at Elville and Associates, I know we are always working hard to help to develop our championship team of knowledgeable attorneys that are going to be educating clients, educating the public. And I think each one of you can take this material today and say, yes, we need to do a lot of public education about supported decision making so that even though it may not be of utility to everyone, that it does advance human rights for those persons with disabilities and will have a big impact in society. But we need to educate people about that. I also have a public interest project going to try to do that through film and audio. So if anyone is interested in that, that is something that I'm developing, and we could talk about that at another time.
Steve.
Yeah, I'm going to stop for just a second because this is the last part of the presentation.
Steve, you're reading my mind. I do have a couple of questions here, and now would be a great time to do those before we go into the legislation. So let's see. First one is guardianship with supported decision making. Are circumstances where the individual would like support specifically identified, or as individual requests the support? Is guardianship with supported decision making protection with rights?
Thank you for that wonderful question. I'm going to try to answer that in a sensible way. We're still seeing and looking and seeing what this is going to mean. So courts now all of a sudden have this power, and as you're going to see in the legislation here, the guardian has to actually agree for the unless the court overrules the guardian. The person who's appointed as guardian has to agree that a supported decision maker element can be added to the guardianship. And the way I see it, and we'll have to see how courts are developing this, because we are actually asking for this for some of our clients in various courts. And what it means is the person will be able to say, listen, even though I'm under guardianship and I've technically lost my legal rights to my person, my legal rights to my property, I technically have not lost all of my rights, because if I have a supporting decision maker, that means that that guardian, and hopefully this would have happened anyway, but this is officially, the guardian now has to recognize that I have rights. Now, let's stop there for a second. A person under guardianship, even though we've always said they basically have lost their legal rights, they haven't lost all of them. They still have a right to be heard and so forth. They haven't lost all of their rights in theory. But this supporting decision-making element that can be added to the guardianship order, this basically says that the person retains a theoretical right to direct their own lives to whatever extent possible within reason. And the guardian now has if they are the supporting decision maker, the guardian has to see this person in a different way, that this person's rights should be effectuated and their choices and preferences in a formal way. So I don't know if that's a good answer. I'm trying to do the best I can to answer that question this morning, but I think it's a conceptual addition that expands the person's right of self-determination, even under guardianship, where theoretically they basically had lost all rights or nearly all rights. And a court could, I'm certainly thinking, a court could certainly say, well, now this person not only has a supported decision maker under guardianship, but that supported decision maker must agree to effectuate these particular kinds of choices. This person has some say in their own health care. This person has some say in this. And we're just going to have to see how courts articulate that in these agreements, or whether they're going to not the agreement itself, but as part of guardianship, and how expansive that's going to be.
Okay. Next question. What does the capacity of the person with a disability have to do with determining supported decision-making versus guardianship is best?
All right, and thank you for that really great question. So as we go back to that continuum, which I'm going to go back to very briefly here, as we go back to this continuum, I want you to look at guardianship and the concepts of incapacity versus capacity in a whole different way. So again, I'm going to tell you what I know, and then you'll have to draw your own conclusions. So let's say I'm a person with very significant disabilities. I may have intellectual disabilities to such an extent that I can't make my own decisions, that really keep me from being vulnerable. I am vulnerable, but I want to go to a baseball game. I know that. And I want to see the St. Louis Cardinals, the Wrecking Crew, come into Baltimore. And I want to go see this game. And I want a hot dog. I know those things. Okay. Now, my simple example about wanting to be a person who goes to support the Cardinals, I wear my Cardinal hat, I want a hot dog at Camden Yards. That is me saying what I want and determining what I want, and I need someone to help me get there. That simple example shows that no matter how higher functioning or how lower functioning a person with very significant disabilities, I can express my wishes and desires. A supporting decision maker is a person to help me effectuate that. And you see, it throws out the window the old notions of capacity or incapacity. And many of you may say, well, Steve, I would have done that anyway. I would make sure that my loved one could go to the ball game and get a hot dog. And I know you would. The difference is that it's now formalized in the law that I, as that disabled person, no matter what my level of capacity, in theory, I have this right of self-determination that's recognized under the law that I did not have before. I'm hoping as you kind of look on this continuum, see, you'll say, well, okay, does my loved one need a guardianship? And my question to many parents is your loved one vulnerable? And what is that degree of vulnerability, which of course is a different subject for a different day. But this all becomes part of the same discussion: the right to self-determine, the right to exercise capacity, the right to avoid a guardianship, or our recognition of the fact that this person actually needs a guardianship and a court might adjudicate that they actually need protection. All of that is on this continuum, and supported decision making is a tool that we did not have before. Okay, I hope that helps.
Thank you, Steve. One more question. What happens if your adult child with a disability is sued? What are the implications if the adult child is under parental guardianship versus supported decision making?
Well, that's a wonderful question, and it's a very broad question, so I'll try to make sense of it. If you have an adult child under guardianship and that child is sued, well, that child is not deemed to have capacity, depending on the nature of the full guardianship order that would have, let's say, removed their rights. Now, what's difficult to answer about this question is, where does a guardian or a non-guardian parent or loved one of a person, where do they start to have liability? And this is again, something that's probably not possible to answer correctly in this particular webinar, but I would simply come down to this: if you are acting reasonably as a person, whether you are a guardian of another or whether you are the parent of an adult child who is not under guardianship, if you are acting reasonably with regard to their support, in my opinion, generally speaking, you would not be liable for the actions of that person. You just couldn't be. But if you were knowledgeable, let's say that I have a relative and I know that person, and I'm responsible for that person in the sense that they live with me, or I'm their agent, or maybe I'm their agent under a document 20 years old that they signed 20 years earlier. And I know that person has dementia. And I know that person's dementia is such that their doctor said they couldn't drive. But I allow that person in my own home to have access to my vehicle, to keys, to get in the vehicle. That person goes out and causes damage or kills someone or injures someone. Now I think I start to have liability because I was aware and I knew that I was exposing others to danger because of this person's proclivity to go out and get into a car and take off. So I think that as long as you're acting reasonably under the circumstances and you're not enabling someone to do something that is unreasonable, and let's say that you're doing all of that, you're doing all of the right things, and this person goes out and causes damage or otherwise, but you have not facilitated that and you're acting reasonably, I don't think that you would be liable. But that's a very, very general answer, and I hope that helps.
Okay, thank you, Steve.
You're welcome. And thank you for those wonderful questions. So as we start to wrap up, and I'm cognizant of our time, let's look at the new Maryland supported decision-making law. Now, I wrote an article, and Jeff is happy to make this available to you. It's in our newsletter of one edition ago from the winter, or maybe even last summer, Jeff. But that article, not just because I wrote it, but it includes many of these things. And if you'd like to read that, I think it's an article that's worth reading. We have seen that it's #1 on Google. And I think the reason it's #1 is not because I wrote it, but because I'm really defining through including excerpts of the Maryland law about how to really think about supported decision making. So we have definitions, just like in all laws. I'm going to point out some of the most significant things here. So a person can have a supporting decision maker with or without a written agreement. So we talked about that. That's a bit of a shocker for some people. It's a series of relationships. It could be that the person appoints 4 supported decision makers. And many of you might say, well, Steve, I'm shaking my head already. This is just craziness. But again, this is just to show the scope of this incredibly expanded notion of human rights. To communicate or effectuate the adult's own life decisions. Let's go back to my example where a disabled person says they want to go to the ball game, okay? They are making or communicating or effectuating their own life decisions. And you may say, Steve, I've always helped my loved one do that, and I know you have, but now this is more formal under the law. It expands their rights. Notice again that this is an arrangement. It can be for one supporter or many supporters. And the agreement, and we recommend, of course, that it should be written, and we do have a written supported decision-making agreement that we've developed, and it is going to continue to develop. Why did we create a written agreement? Because Maryland does not provide for one. Now, some states like Indiana, they have an agreement that's right there. You can use it. It's very broad. Maryland has chosen not to provide for that. So we have created one, and it can be customized for people to talk about the rights of the adult, the reasons why supported decision-making can be used, and the responsibilities of the supporter. Now, what is a supporter? An individual selected by the adult, I should say an individual or individuals, to provide support and to, again, repeating myself, providing support to help the person make, communicate, or effectuate their own, not the decision maker, but their own life decisions. The purpose of supported decision making, now this is the definition from the statute. It is to assist adults in obtaining, making, communicating, effectuating, and corresponding with the decisions of the adult and the preferences of the adult. And again, the statute is very clear, and I think when you take the time to read this or see the article, it really talks very clearly about keeping someone from making decisions for another without good justification, meaning a supporting decision maker cannot do that. So the purpose of the statute is to prevent the appointment of a substitute decision maker, including a guardian. It says right there in the statute. Now, supported decision-making can be used to increase the adult self-determination, prevent the the substitute decision maker, to prevent an agent or guardian, and to limit or terminate the use of a substitute decision maker. And for a couple of you that have asked questions this morning, I think this next bullet point is the thing that just says it all. This statute is so broad, I want you to not try to judge it today. I don't want you to try to get your minds around it too much because it can be confusing, and to just let it sink in and try to determine what this means for you. All adults, regardless of capacity, are presumed capable of making a supported decision-making agreement, and the statute specifically says this is to be construed liberally. Okay, this is not a grounds for determining the adult's capability. So along the lines that any person can make an agreement regardless, again, it's extremely broad. If a person can't make that decision, can't make the agreement, they don't have the real capacity to do it, we can't then say, oh, that person couldn't make their own decision, so they're incapacitated. So this says it cannot be used as a grounds for determining the person is incapacitated. It's extremely broad. It can't be used as evidence of incapacity. There's no risk to them signing, no risk to them not being able to sign or verbalize. Now, we talked about the guardianship. Not all states have this. Not all states say that you can have a supported decision maker under guardianship. So we're very lucky in this sense that many of you that have loved ones under guardianship, you now can consider, and they can consider, do I have or do I want to have a supporting decision maker under a guardianship? So in Maryland, a person under guardianship may enter into a supported decision-making agreement. The court may limit or remove guardianship due to the existence of supported decision-making, and a guardian cannot say no. They cannot prevent this without good cause. Right now, I know some of you are feeling stress just from hearing this, but I encourage you to understand that this is just the arrival of a new set of a new paradigm. And it doesn't necessarily mean it's going to change things for you. It is simply a recognition of people's rights, even with disabilities. What is support? Gathering information, understanding and interpreting information, helping a person weigh their options, understanding pros and cons and consequences, participating in conversations with third parties. Imagine your loved one with disabilities going into the bank with the supporter and being able to make a transaction at the bank if they weren't previously able to do that by themselves, to be able to do this now officially, and the people at the bank have to recognize the person with disabilities is the person that's making their decisions in coordination with the supporter who is helping them. And that gets to the last bullet point here, providing support to the adult in implementing a decision. The supporter has responsibilities. They have to support the will and the preferences of the adult without inserting their own opinion about the reasonableness of that person's preferences. Very broad. To act honestly, diligently, and in good faith. Act within the scope of the agreement. Maintain records of the supporter's actions, how they communicate, okay? Recording such things and maintaining safety and security and retaining a relationship of trust and confidence. Very important slide here. A supported decision maker cannot make decisions for the adult, exert undue influence on the adult. Many of my elder law colleagues were very, very concerned about this, and rightly so. The law says a supporting decision maker may not exert undue influence, coerce the adult, obtain information about the adult without their consent, enforce decisions made by the adult outside of their preferences, as we mentioned earlier, or act outside of the authority of the agreement. A supporter may not be a minor. A supporter cannot be a person with whom the adult has said, hey, I've got a peace order against you. You can't come near me. Cannot be a supporter. Or a person who has been convicted of financial exploitation. Now, a supporter can resign. A supporter can say, I'm not doing this. They have to give oral resignation or provide it in writing, okay? And they must give it to the supporter and all third parties who have the agreement on file. And of course, the authority of a supporter, just like if the supporter were an agent, which they're not necessarily, the authority of the supporter ends upon their incapacity or death. Now, I won't necessarily, in the interest of time, get into all the requirements of a supported decision-making agreement. This is where we take the statute and create an agreement, which Elville and Associates has created. But this agreement can be very, very flexible. It says it can be in any form that is consistent with the statute. So you see, this statute is going from 0 to 100 miles an hour, okay? And it's designed so it's not an impediment to the person being able to have a supporter, okay? It must be documented, dated, and witnessed, and so forth. It must name at least one supporter, describe decision-making, describe the supporters and how they should work together, and describe any potential conflicts of interest, how they could be mitigated. Document the adult selected, how the adult selected, be approved by the court if there is a guardian. Remember, the court is the ultimate guardian. They have to approve it. And it must contain an attestation about the adult's independence in decision-making. Now, the adult can revoke the agreement orally or in writing. I know that drives some of you crazy from the beginning, but remember, this is a new recognition of rights. Third parties can rely on the supported decision-making in good faith. This is possibly one of the most important of all of these review bullet points here, that it's a formalized way to obviously increase self-determination, but it's also a recognized or a new way that third parties may rely on such laws, okay? Third parties may also decline to comply with a supported decision-making agreement if they have actual knowledge of invalidity, revocation, abrogation, or coercion or undue influence of a supporter. That's very good there. I like that. Third parties can be held liable for causing personal injury, negligence, intentional acts. This is a big one. Third parties can be held liable for failing to give effect to the adult's decisions. So you see, this law does have teeth. It's very broad. It's hard to get our minds around, our hands around, but it has teeth. They can be held liable for failing to provide information to the adult or the supporter that would be necessary, and they are liable for actions inconsistent with the law. Now, how can supported decision-making, as we wrap up, how can it benefit persons with disabilities? I thank you all for really staying with me through this. Persons with disabilities are no longer strictly limited by their own diminished capacity. This is what I want you to walk away with. The paradigm of risk should encourage the ideal of independence during a road of recovery. Let's say someone had a traumatic brain injury, okay? They many times have a long road to recovery. This will encourage independence during such a time. New empowerment and recognition of rights. We talked about that, and I know I've talked about that over and over. New and ideally articulated role for supporters. It's a new legal path forward, a psychological shift. The ideals of independence and right of self-determination are not diminished by any need for guardianship. So where we many times say, oh my God, we're having to get guardianship, this is terrible, it's taking away the rights of our loved ones. Well, not necessarily anymore. Yes, the loved one is losing a lot of rights, but not all. And this is a formal recognition. And then again, new protections from guardianship itself where it is not truly necessary. All right, that is an awful lot. We're going to end here now, and I'm going to turn it back to Jeff. But I just want to congratulate you for, your commitment, for sitting through so much dense information. You've allowed me to go around the world from what supported decision making is versus what it is not. I've gone down the continuum of self-determination from east to west and west to east. And we would just encourage you to walk away, think through this, talk to us, set a time to meet with us, set a time to meet with me. If you have questions, I'll help you work through it. We'll decide questions about guardianship versus no guardianship. We'll talk about special needs planning and how all this relates to our loved one with special needs. We encourage you to complete a questionnaire. Don't worry, there's nothing to fear. We do have an attorney-client relationship. If you come and talk to me or any of our lawyers here at Elville and Associates, even if you do not become a client, we are engaging in a confidential discussion. There is nothing to fear there. Bring your current estate planning documents. Bring your questions. We love questions. We are here to educate. We feel we're one of the only law firms in Maryland that actually educates our clients. We want to give you time to think. We know you don't have a lot of time to think, and we want to use our conference rooms, our resources to give you that time to think. If you don't have an advisory team around you and your loved one, we want to help you to form that team. And again, we will help you with a supported decision-making agreement or to wrap your minds around the concepts of supported decision-making, even in the presence of your loved one with disabilities, of course, who may be the person who wants a supported decision-making agreement, and to learn about it in conjunction with you and your family. Thank you all, and I wish you a happy Easter and Passover. Jeff, I'm going to turn it back to you, and I think we're on time. Thank you.
We are. Thank you, Steve. Let's see if we have any other questions. Thanks, Steve, for sharing your thoughts today and your knowledge about this really important topic. Everywhere we go, a lot of interesting thoughts and opinions and ideas, and we're really privileged to be able to speak about it in a lot of great settings, including today. So it looks like we do have a couple more questions before we wrap up here. And the first one says, is it required that the individual with a disability determine who will be their health care and financial power of attorney? Could a parent declare themselves as the power of attorney?
Thank you for that question. It is not required for a person to determine that they will have an agent under a power of attorney or a healthcare directive. However, it's advisable. It's not required, but the person with the capacity to do so, who does not need a guardianship, so to speak, should appoint an agent. And this is a problem for many families where a loved one with disabilities needs to probably execute those documents. In theory, they need to, but maybe they won't. Now, when they do, of course, they're avoiding guardianship where appropriate. They are waiving HIPAA, so you can get medical records even after they're an adult. All of these things are vital things to do, but let's say they won't do it. You can't insert yourself, unfortunately, because that adult who's over 18, that person has their own rights and their own self-determination. They are an adult, and if they refuse to sign those documents, that is where many people are in limbo. Many families who want to have everything together and in place, it's just not happening. So we are here to try to help if we can either mediate or come to some kind of a sensible solution. But the answer to your question is it's not required of the person, and you can't insert yourself as someone else's agent, unfortunately. But hopefully we could work toward some kind of reasonable solution depending on the situation.
Very good. And last question for now, and now would be your time to get those final questions in for Steve. What would cause, sorry, looks like it just jumped down because we had another one. Where did it go? There it goes. What would cause the court to limit or remove guardianship with supported decision making?
That's a very good question. I think that This is a brand new question. And only in the last 2 or 3 years have I seen anything that would suggest that courts are actually willing to do this. And then, of course, supported decision making came along. And I think it forces the court to have to agree that if a person were to, or an interested person, were to produce 2 physician statements that said the person that previously had been under guardianship by evidence of 2 physician statements that that person was incapacitated. But now we have 2 physician statements that say that person is not a person with disabilities, meaning they're not incapacitated by way of those prior, that prior proof, that prior evidence. 2 physician statements that prove the opposite, I think, is clearly one of the bases of that. The other way I think of looking at it is, and I do think you would have to have that kind of proof, but if you didn't, there might be other ways to present that case to the court. We'd have to talk about that individually, but I would walk away from this presentation today thinking I probably have to have 2 physician statements of capacity to be able to go into a situation to have a private guardianship undone and terminated.
Okay, and last question for now. How does the Maryland Healthcare Act regarding hierarchy of decision makers play a role?
Thank you for that question. To my knowledge, and I want to put a big star beside this, I'm not 100% sure about this. This is maybe a very, very general answer. I don't think that has anything to do with it. I think that I have no reason to believe that supported decision making has any relation to that as far as this hierarchy of surrogate decision makers. I think just making sure that we're on the same page about that. If a person has no agent, they can still avoid guardianship, of course, with this hierarchy of decision makers on the healthcare side, not on the financial side. There is no substitute for guardianship on the financial side with a surrogate. So on the healthcare side, there is this order of priority, if that's what you're talking about. And I think that that is what it is. It's a substitute for guardianship, potentially. And it has nothing to do with the order of priority, because there doesn't seem to be an order of priority type of arrangement contemplated under the supported decision making. So I don't think it's related at all, at least right now.
Okay, very good. Okay, well, thank you. And had several questions about the session being recorded. And as always, all of our sessions here through our webinar series are recorded, and you'll be sent the recording in my post-webinar follow-up email that I send out to everybody that registers for the presentation. And I'll also share the article that Steve alluded to. It's also in the chat if you wanted to read it right now. As far as our webinar series goes, we're going to be very busy in April. We've already been busy. We visited the library, Howard County Elk Ridge branch on Wednesday, talking about special needs planning. We have today, and then Monday the 17th, we have webinar Safely Navigating Healthcare and COVID with Your Living Will. And Tuesday the 18th, we have guardianship. What is it? When is it appropriate? And what are some alternatives? And then on Thursday the 20th, webinar State of Today's Real Estate Market. So 3 interesting ones all in a row there in a couple of weeks. So look forward to seeing you then. If there's anything we can do for you here at Elville & Associates, let us know. Certainly be in great hands with Steve, of course. And we appreciate your interest in our webinar series in Elville & Associates, and look forward to hosting you again soon, and hope you have a really great weekend. We'll see you again. Thanks very much.